Good evening. Welcome to Money Mondays, a series on legal rights during the COVID-19 pandemic. Money Mondays is brought to you through partnership with the St. Louis Regional Financial Empowerment Coalition. The St. Louis Regional Financial Empowerment Coalition desires to bring you reliable information about your financial rights. The Financial Empowerment Coalition is a group of community partners dedicated to increasing self-sufficiency and prosperity through financial education and asset building. For more information, please visit www.moneysmartstlouis.org. At Legal Services of Eastern Missouri, we act for others. We are a voice for justice, and our actions provide hope. We want you to know that we remain dedicated to helping individuals, families, and small businesses in need during the COVID-19 pandemic. Tonight, we are joined by Ms. Tracy James, Managing Attorney of the Community Economic Development Program at Legal Services of Eastern Missouri. Ms. James will discuss COVID's impact on business leases and contracts. Please note that our presenter will not be able to see your questions or comments while speaking. Ms. James will try to address your concerns live at the end of the presentation. We'd like to acknowledge and thank members of our team for their assistance in the chat section. I will now turn the presentation over to Ms. James.
Thank you, appreciate it. Hi, I'm Tracy James, and I am here to talk about contracts and leases today. Appreciate Tasha and also Brittany, who are working behind the scenes to make this presentation possible. So today, we're going to go ahead and kind of a roadmap of what we're going to talk about, which is contracts and leases. So basically, during this crisis, we just had the stay-at-home order dissolved for the city and the county, St. Louis County, of course, St. Louis City, and of course, St. Charles County had already expired prior. But what do we have to do as a business or a nonprofit if we are facing issues due to COVID? And so that's what we're going to talk about today. It's still ongoing. It hasn't disappeared. And some of the businesses are coming back and reopening. And so it's kind of time to look over, dust off the contracts or maybe the leases that you have, and finding out, if you haven't already, what are your rights in order to go ahead and manage this crisis effectively to kind of minimize the harm that is to your business, to your livelihood, and to your staff. So what we're going to talk about today are a couple of things, and this is kind of a roadmap is where we're going, is to basically kind of give a little bit of a background about contracts, what they are, just as a refresher. Where are you in completing the contract or lease, and why is this important? What do you want to do about avoiding a breach of a contract, okay? If you have already done so. What are your defenses? Do you have any defenses to a contract? What is it, or when is it when enforcing a contract is not possible? And then lastly, what other defenses do you have in the lease? Is there something else that's specified or in a contract? What can you do? And then also, what if it's too late? What happens if everything's already passed by? How can you kind of lessen your losses, as I say, looking at remedies and contracts and also in leases? So that's kind of what we're going to talk about today. And I really appreciate you joining us this evening. So if we go to the first one under understanding contracts, hopefully. All right. So kind of giving you a background, if you don't already know, is that talking about overall contracts. One is an agreement between two or more parties. That's what a contract is. And an agreement is where you have two or more parties talking about what they want to do at a particular time. And someone will either pay or do something in receipt of getting a service or a good, right? So it's basically to do what? To produce a product or a service for a particular price. Maybe it's market price, all that's needed, bulk price, cost per item or for service. For how long? Is it a month to month? Is it up until 100 units? Is it for a year, etc.? And then also a lease. A lease is like a contract. It is a contract, but it also includes possession of land or property, okay, between two or more parties to do something. A landlord provides space and a tenant occupies space for a particular price, monthly, yearly. And then for how long? Month to month, 6 months, a year, 1 or more years. So we're going to talk about those two, and I'll be using a lot of interchangeably. But if I talk specifically about leases, that will be about leases itself, which is a kind of a type of contract. So when a party does not hold up their end of the bargain, their end of the agreement, that is a breach or a break in the contract or in the agreement. All right. So going back to the next one, it's all fact dependent too. So it depends on the facts, the circumstances, the language of the contract. And of course, contracts can be written and they can be oral. So hopefully that there are written contracts. And you might have things that are written, but also outside of the contract itself. People might be doing things outside of it that's not actually in the contract. So the hope is that you have a written contract. Okay, the second part of this, and one of the factors to look at, is where are you in performing the contract or the lease? Where are the parties at? Okay, and I think depending on where you are in that process, tells you what kind of choices that you have and that you can make in trying to kind of deal with this crisis, okay? Because we haven't had this type of crisis before. I mean, we've had SARS, and we've maybe had Ebola in some areas, not Africa, but definitely since the 1918 pandemic, we really haven't had this type of crisis before that has affected the entire economy. Okay, so where are we at? Are all the parties, have they signed the contract? Have both of them done that? Are they thinking about it? Okay. Has one party already performed the contract? Where are you at in this? If you've already had you've sold some widgets, right? You sold a pack of, a pellet of onions, all right? And what's left is maybe either delivery or maybe even payment. Have all the parties then met all the conditions of the contract? Conditions meaning, is there something that's part of it that maybe has a time element that you're supposed to deliver something? You're supposed to pay something. You're supposed to notify somebody. You're supposed to, you could have, you're supposed to deliver this pellet of onions on the 3rd Thursday of the month. And if there's a flag outside, maybe, and they're saying that they don't need it, then it's maybe the next Tuesday following. So there's different conditions. Where are you at in that? Have you already missed a deadline? Have you missed an order? Have you missed a delivery? My guess is, unless you are an essential business, that might have happened already. And it might be continuing to happen with maybe many different vendors. What about payment? Now that's the big question. What about payment? Have you missed a payment? Have you not received what you're owed? There's a lot of people hurting out there. And so this is going to be on the minds of a lot of people as it's going on. So basically, has a breach of the contract already occurred? So from the very beginning to the very end, you might not see, you might not have all these particular parts done. Where you're at is maybe we'll limit those choices or have those choices provided. If you're completely done and all you're doing is, okay, you've definitely breached, then that might be a big particular problem too. Why is this important? So asking kind of a follow-up question to where are you in completing the contract or the lease? Why is this important? So it depends where you are in fulfilling the contract. So when COVID has affected your business, you can see what kind of legal protection you have. Hopefully you have legal protection, I think you do, and how to react so that you can lower your risk of being exposed, okay? And reducing your liability, meaning how much money do you owe, all right? So if you wanna make sure that your business is successful and you wanna kind of lower those risks. So then this goes back to, okay, all right. what do you want to do to avoid breaching the contract? So if you haven't already breached the contract, you've gone through this whole life cycle of the contract and you have not breached anything at all, there are some things that you can do, some steps that you can do that to avoid hurting your own business, your livelihood, your continuation, and also to save you some money in some way, shape, or form. So as I mentioned before, a breach is a break, okay, where you've somehow broken the contract. It could be in many different ways or forms. It could be a complete or substantial failure to perform or to do that part of the contract that's required. It could be, all of it or some of it, most of it. It could be where you've done the opposite, where you've done a lot of it, but you haven't done maybe just 10% or 15%. You've done substantial but not complete performance. You've not done all you're required to do in the contract. Maybe you've done, there's some words or there's some emails, there's been some action, some conduct, telephone calls, things like that have been reasonably interpreted as a refusal to perform. I will not do this. That's called repudiation. Has that happened yet? Okay. Another, that could be a breach as well. Another one is anticipatory breach. Let's say you saw this coming. You have a contract and you saw this coming, this COVID crisis, and that we all have the stay-at-home order and that you're not an essential business, right? You might inform the other party ahead of time, before the stay-at-home order even happened, that you were not going to be able to perform. You see it coming. You read the tea leaves. You read the news. Okay. Another way that you can do a breach is changing the circumstance. It all depends on the facts, though, is that the circumstances have changed since you originally signed the contract. And when it becomes impossible to fulfill your part of the bargain, or the other party has done that, then that's a breach as well. Okay, so you want to try and avoid those things as much as possible. Well, what happens if you have, okay? And we want to kind of look at a couple of different terms, especially if you take a look at your contract or your lease. So there's a couple of different terms that might be really helpful to look at. One is default. Default is kind of the overall, oh my gosh, the contract's completely blown. It's a general term for failing to fulfill the terms of the contract, but often more specifically, refusal to pay a debt when it's owed. Okay, you usually see this that you're in default. I think one of our colleagues, Terry Lawson, talked about student loans and avoiding default of your student loan. That's a contract as well. So that, and not avoiding paying what you've been owed. So for example, if a buyer does not pay the entire shipment by May 15th, the buyer will be in default of the contract, and the seller will have an immediate recourse for the recovery of all amounts due. So that means you might see that language in that contract. So if you don't deliver, right, or you don't pay, then you could be in default, and that you might have an acceleration clause in it that you might have to pay immediately. That's a big deal. You might have many different breaches, many different breaks that do not lead to a default of the contract, but it just depends. Again, a breach of contract is a broken promise or failure by one or both parties without a legal excuse. We want to see if we can get you a legal excuse, a get out of jail free card for thinking like Monopoly, being able to kind of give you another chance to kind of come above this whole fiasco with virus. Unfortunately, if you don't have a legal excuse, a breach can lead to a default. You might have, as I mentioned, many different breaches, and then it depends on what that might mean for a default. An example is, if you might see this in a lease, the rent shall be due by the 1st of the month, but no later than the 10th of the month, with a 10% late fee. If payment has not been paid by the 15th of the month, it will be considered a breach of the lease. Upon landlord's option, non-payment is a major breach of the lease and default. Okay, so if you don't pay, then that's a default, and you would owe everything, and you can't get out of jail free kind of card. You don't get an excuse in order to do that if you have a complete default of the entire contract. So we want to kind of look at those terms in your agreement that you have, looking for those specific words if that's possible. So you might want to, if you have that, that would be good to look for. So the next thing that you want to do is, if you have something that a breach, then you want to try and find a way out, a legal excuse. Okay, when a contract or lease may be unenforceable, it might be unenforceable in that part or maybe in the whole. It just depends on the facts of the situation. Now, conditions, there's certain conditions that are apparent with this whole virus that can excuse you from having to perform or fulfill the duties of the contract. Now, I want to make sure that this is clear, that an inability to pay in and of itself is not going to be a legal excuse. You cannot usually be, excused for not having money. All right. It's just what you want to see what you can do about trying to lower the amount of what you owe, lessen, have it cheaper if you can, or do some certain things that you can try and get you help in some way. So I'm going to talk about a couple of different things here. And there are 3 avenues of relief and excused performance, okay? And so one is impracticability. That's a wonderful term, and it looks just like the other one right below it, impossibility. Impracticability is like, it's impracticable for me to do something. It's a subjective belief based on a particular party, all right, that they think that an unforeseen condition or event has occurred that makes it very, very difficult or even expensive for the party who is supposed to do it. Okay, so I don't want to go ahead and do this because it might be really expensive for me, and I might have to do all of these things to do it. That's impracticability. And usually you see that when there's a seller of goods or services, that they usually use that as a particular type of excuse. An example, the singer Zyla is contracted to perform in Atlanta on Friday night, but it will be impracticable for him to do so if his entire 42-person crew needs to be tested for the virus and cleared 24 hours ahead of time before boarding a flight and arriving in Atlanta ahead of the concert time. It might be really expensive to try and get them all tested and cleared before they're able to go, all right? So that is one way. Another one is impossibility. That's an objective belief. That means that's by a reasonable person, someone who's maybe not a party to the contract. An outsider might say, oh yeah, that's kind of not, you're not able to really do this, so it's impossible. You can't be at 2 places at once. That's impossible. So an objective belief triggered by the occurrence of a condition, COVID, which prevents one party from fulfilling the contract. The condition excuses performance. It gets a get out of jail free card kind of thing. The party seeking this defense must have explored every other option available within its powers to perform the contract. So basically, using the same example, but taking it a little differently, Zyla is under mandatory quarantine, is under a stay-at-home order, and is testing positive for COVID, oh dear, and cannot perform the concert in Atlanta on Saturday. Well, that could be argued as an impossibility, and that would be something that, again, a seller, more often than not, is going to bring this up as a defense to performing the contract. So the facts would be changed if Zyla knew and was doing things that he wasn't supposed to be doing and having a party with a lot of people in very close proximity. That might change the facts a little differently. So that's why facts are really important and looking at the language of the contract. Okay, so that's one thing. You might not even have some of these things in the contract itself. They could be called gap fillers that Missouri law would provide. Another avenue for an out, so to speak, is a frustration of purpose. I'm really frustrated that my whole idea that I wanted to do something has been denied. One would be, I wanted to have this particular singer come to St. Louis and perform in my venue. And then COVID happens and the singer dies, unfortunately. Then your whole reason for having this contract, that whole frustration of purpose, then that's a problem. So it's usually after the contract is made, an unforeseen event, COVID, not caused or foreseen by either party, undermines a party's main reason for even being into the contract in the first place. So that the party contracting it does not get any value. So I can't really do anything with a dead performer if I'm trying to maybe have a concert in my venue. The party's remaining duties are discharged from being carried out. So let's say Acme Concert Performances, Inc., which would be running the concerts and finding places for the Xyla to perform in different cities, has contracted Xyla to do a 3-hour performance on May 1st at, let's say, the Stiefel Concert Hall or Opera House or whatever it's called now. And so it's supposed to do a 3-hour performance on May 1st, but due to a stay-at-home order by the City of St. Louis's Department of Health, they have a stay-at-home order because of the coronavirus, can't do it, and cannot reasonably perform this in the near future. That's why you see a lot of contracts with different concerts being canceled because there's no venue at all that can be open at that time. So that's a frustration of purpose. And that's usually the purpose is the purchaser. Acme is trying to make a contract with some of the other venues as well. So you have to make sure if you might fit one of these particular situations. And again, timing and where you're at in the contract is very important. So what about defenses to breach? When a contract or a lease may be unenforceable at all. You just can't do anything about it. You put a fork in it, there's nothing going to happen, right? Unforeseeable circumstances. It's not expected and usually goes with the term reasonably foreseeable, meaning the average person isn't going to expect for this to happen. So you might see this in a lease. If the entire premise is destroyed by fire, unforeseen nor caused by either party, and if the premises are completely destroyed, then the landlord will send notice to tenant within 30 days of the fire stating the landlord will not rebuild and that the lease is now null and void absent any payments already made. You might see that in a lease for a fire. You also get fire insurance because it might be foreseeable that there is a fire, but it might be unforeseeable if it's a neighbor's fire and your building catches on fire, right? And you are a tenant. And so that is unforeseeable. You didn't see that was happening, right? The same thing with COVID. It all depends on where you're at in the contract, if it's unforeseeable at all. So for instance, I cannot expect it to happen. So if you have some of these going on, I want you to take a look for them in the contract. These are kind of like get out of jail free cards, okay? These are called legal excuses. And so when you have a condition in the contract or a lease, you want to look for these words. They don't necessarily, they're not necessarily required, but it's very helpful if you do have them. So one of them is force majeure. That's French for superior force. So it's a common contract clause that frees both the parties from liability, from obligation, from performing when an extraordinary event or circumstance beyond the control of the parties occurs. So that's kind of a general umbrella definition. And so there's going to be some examples of that. Force majeure talks about all different things. Okay, so it just means something happens outside the control of what you expected. So one particular type of force majeure is an act of God. So that's just kind of an old-fashioned term, but it's been in tradition for a long period of time. It is a kind of force majeure. It's normally not caused by humans, not normally, and it's very unexpected. Tornadoes, plague, riots that could be caused by humans, but it's very unforeseeable. You don't expect this to happen. Nuclear, assured destruction. You might have some sort of mutual assured destruction through nuclear warheads that might not be in there. It's probably completely unforeseeable unless that you're contracting in a war zone, right? But it's often spelled out, but not always. So some of the words that you might see is a pandemic. Plague might be similar, but a pandemic. After 9/11 happened, there were many force majeure clauses that included acts of terrorism as an act of God. Okay, even though it was caused by humans, that might not be foreseeable when you're deciding to go ahead to buy or sell toys, for instance. That's not going to be in the scope of what you're thinking. And so Missouri has said that natural causes are normally not foreseeable and was not due to any participation of man or humans. So even though COVID-19 is caused by a virus that's in part by nature, but due to man's or humans' participation and maybe worsening of it, like maybe going from point A to point B, and the volume of media attention that's happened, it might not be seen as an act of God. It just depends on where you're at in the contract, in the life of the contract. So when you think that part of it is prescribed by man, or somehow humans have done something through active or neglect, active intervention or neglect or failure to act, that means that the whole thing is humanized, and that means you can't necessarily use it. So that's why you look at when was the contract made, where are you at in it. So events beyond the party's control. So hopefully there's no standard force majeure clauses. Everything is going to be very, very fact specific. That's why you need to take a look, dust off your contract, dust off your lease, see what you need to do. What are some of the requirements that you need to do in order to maybe take advantage of some of these contract clauses. Now, there's some other things to look for in leases specifically. So one is continuous operation, all right? You might see that in your lease. I'm talking about commercial leases now versus residential leases, since we're talking about businesses and nonprofits. So it means that a tenant must remain open for business under normal circumstances or face breaching the lease. So you might see an example of this in the lease. Tenant agrees to be open for business during normal business hours and agrees to be in continuous operation during the lease unless giving the landlord advance notice and subject to pre-approval. Okay, so unless you had a crystal ball and you're able to predict that there was going to be a stay-at-home order in place for a period of 2 months, 6 weeks, 2 months, and you could tell them ahead of time, okay, I need to have pre-approval. I'm not going to be in continuous business. I can't operate. I'm not an essential business. So you look out for that phrase in your lease. So that's one thing that might get you off the hook. Another one is a right of re-entry. I hate to see them in here, but sometimes that happens. It depends on the situation again. You might see this in the lease, which is a term giving the landlord the right to enter a leased space and do something with it. There's usually a condition that happens ahead of time in order to have this clause kind of triggered, so to speak. The example language is if a tenant abandons the property, the landlord has the right of re-entry to the leased premises upon the discovery of or tenant's notice. All right. So if you abandon, if you're the tenant and you're in the space and you are subject to a stay-at-home order and you cannot be open and you're not coming in, all right, you're not an essential business, it's not open. The landlord might think that by your lack of presence there, that maybe you haven't gotten any notice, you haven't received anything, either by action or by word or something, that you've abandoned it. Then that might trigger the landlord coming in and taking the space over, taking your stuff out, and then billing you for a lot of money. So look for those two phrases or clauses in your lease. And that will be helpful to look at to see if either of those events have occurred. So, okay, so what can you do? We're looking at what can you do? You see all these different things happening. What each step can you possibly do in order to kind of head this off? So again, it goes back to where you're at in performing the contract. Now, if you haven't signed anything, oh my gosh, hold on, wait until you know that your particular business is going to be open. You know, if you're a nail salon, for instance, and you haven't signed anything, probably a good idea to hold off until you know for sure that nail salons can be open right now. And you don't want to be wasting your money signing a contract, right? So just hold off on that. Now, let's say you've signed the contract, but neither party has performed. Let the other party know now of the problems due to COVID. Hopefully you have had that kind of relationship with the other party, the other contracting party, and you have been in communication. You've let them know, or they've let you know, that there are certain issues that are going on, okay, that's outside of your control. That would be a great idea. I mean, always communicate is great rather than not communicate. So if one party has performed, but the other one hasn't, let's say they've made a whole bunch of toys, but they haven't delivered it, okay? Or they haven't, you haven't received it because your business isn't open and you can't open up to do that. Have all the conditions been met? Can one party still complete the contract? Look to see if any of those terms are mentioned. Has there something like, act of God, force majeure, have other notice provisions or conditions been met? If you're supposed to kind of be there on the third Thursday to pick up the stuff and your business has been closed, well then no, okay? Hasn't been triggered. If it hasn't, maybe let the party know, or if it has, let them know, because you don't want to get to a certain point and it's too late. Okay, what if none of the terms are in the contract? None at all. So Missouri state law has some gap fillers to fill in what is left unsaid. They'll try and help in those situations. There's something, if they're for a sale of goods, then the Uniform Commercial Code, which is a set of statutes that Missouri has recognized, can come into play. And if it's services, then okay, well, there's other things too. So there are gap fillers out there, like frustration of purpose, impossibility, impracticability. Okay, so those are some of the things that you can do. And if there's other things like government order, like if you have a government order or a government action, like a stay-at-home order, that could be triggered and that could help excuse you from performing. Okay, well, what if we've been doing business together for a while? We have a long-standing relationship and we've been doing this for years and we kind of know how things are going. Well, look at the custom of what you've been doing in the past. Has the other party kind of looked the other way and not been enforcing the contract continually? And there's kind of been things that, and it doesn't say that the other party can do that, for instance, then that means that maybe there is a custom of not enforcing that contract, and you might get away with, with this, because it all depends. If you have been performing the contract and you've had this, and they keep kind of dinging you on things, okay, that's a breach, that's a breach, that's a breach, then that might be a problem too, because then you might be on the hook for it. So it just either ignoring clauses in the past might either help or hurt you, depending on where you're at in the situation. So, I mean, it's really important about timing and notice. So if certain conditions have kind of already come into play, all right, and see if there's some things that you can do to try and lessen this. So I have some ideas for you, even if it's too late. What happens if it's too late? Okay, this is like your if you don't remember anything else, try and remember this. Limit your damages, limit what you owe, limit what your legal exposure is if you're sued, okay? Like you want to kind of limit as much as you can. You want to make sure that your business survives. Look at other remedies. See if there's other opportunities for you to kind of mitigate or take care of the situation. Dialogue helps. Mitigating damages, trying to lessen the damages instead of having a ton of toys being delivered to your toy shop. Maybe you might say, hey, look, I can only do 20% right now. Our business is just reopening. I can't do the whole thing. Can you hold off on this? And then hopefully that they're willing to agree. And if they do have these things where they're willing to agree to things, have it in writing. That really, really helps. Maybe you can go ahead and delay. Maybe you can suspend performances. You might ask for adequate assurances from the other side. There are some legal requirements that might not be in the contract itself, especially for a sale of goods, that if you think that something's going to happen and it hasn't yet, then you would want to get adequate assurances from the other side, limit the damages. Okay, so here I have is a list of things that you can take a look at, and maybe this will help you, all right? So you might ask, okay, suspend payment, suspend performance. If you know that that business is not going to be open and you're selling things to that business, it's a client of yours, then maybe you can say, I'm going to go ahead and hold off right now, and we're going to go ahead and redo this. We're going to go ahead and try and do this in a couple of weeks once your business is up and running. Maybe you can do that. Maybe you can delay or suspend payment. Okay, I'm not letting you pay this now, but in June, you're going to have to pay for April and May's orders. You know, see how that happens. It might help give you some breathing room. Terminating the agreement. You let the other party know, and you just say, I'm done, and see if that, if you can do that, and you kind of see what you can do to kind of lessen your losses, mitigate it. Look at other clauses in the contract for relief. Maybe there are other conditions that haven't been met that you can hang your hat on, so to speak, and use for your benefit. You can ask for damages. You can ask for money. That's what damages are. Ask for money. Or maybe you can put a limit on how much is owed. Maybe you can put a cap on it, or put a floor, like what is the absolute minimum that can be owed for it. See if you have, something like that can help you in some way, shape, or form, or a percentage. You just see what some kind of being creative might help too. Specific performance and forcing the other party to perform the contract, usually with the help of the courts. I'm thinking like, okay, eviction. You really don't want to do self-help eviction. If you're a landlord, that's kind of a no-no under the law. That's, you want to have the help of the courts, kind of that heavy there to do it. And then also knowing that courts are not open, or they're just gradually reopening. And so there's going to be a flood of people rushing to file lawsuits. And right now, for the most part, lawsuits have kind of been put on hold until everything reopens. Okay, restitution. Maybe you cannot do what you were supposed to do, and maybe you can kind of give some other benefit to the contracting party to kind of make them whole again. Restitution. Liquidated damages. Maybe there's something specified in the contract or in the lease. It's a contract clause stating that a fixed amount of money is to be paid in the event of a breach. Maybe you can hang your hat on that one, and rather than, instead of $12,000 being owed, it's like maybe, I don't know, $1,800, especially if you notify them earlier, then it might cut off some of the damages that you have. A substitution. Let's say you cannot produce toys because you can't get your staff back to the factory. And so maybe you have to do something else, like maybe kazoos or a musical instrument. Maybe you can have something that is maybe to a similar benefit. It just depends. And really having an attorney take a look at this at your contract or at your lease might be able to help you, he or she might be able to help you find a way out of this. Okay, so I would always ask for communication, maybe, ask for something in writing if that helps at all. I would also you want to be able to have that communication. So, okay, leases are a little different. So you might want to be able to kind of look at some of these other remedies that you have. One is obligation to pay rent, the right of the tenant to terminate. Let's say you don't have to pay rent if there's an impossibility or frustration of purpose occurs. That would be great. Saying that there's maybe business interruption, there's business continuous operation, and you cannot be open, so that your condition to pay rent has been suspended because of that, because you haven't been able to open. So if you do that, that also might mean that the landlord can't evict you either, okay? So if you can't pay rent because of these things, the landlord can't evict either. So it kind of can go both ways. You can also do rent deferral. So you defer paying the rent until later without any penalty. That's a really good thing. I had one client who was offered to, during the COVID crisis, to not pay rent for March and April, but it would be owed in June and July. So they'd have to double the payments in those 2 months. And that would, gives a little bit of breathing room, especially if you've applied for some of like the PPP or some of the other SBA loans that they might have out there during part of the stimulus package. All right, abandonment. That's another thing we've discussed in the past. Does a lease state when it's happened? what's the tenant's intent? Do you want to go back? Or you just say, I give up, I'm done with this place. I've had problems from the very beginning. I just want to go ahead and walk away and try again somewhere else. Does there a notice provision? Is there a timing and when that's happening? Does when does it show that the tenant intends to abandon the property? Or is it only temporary because of the stay-at-home order? Does the tenant not pay rent, as not collect mail, as fails to visit, as everything been cleaned out of the tenant's space, not anything to do with the landlord? That might look like an abandonment issue. Look out for notices and mailings. That's where the communication, checking on the property is really helpful. Now, the other one, which is not fun on any means, unless you're a landlord, is eviction. Really, in Missouri, there's really no self-help by landlords allowed. Unfortunately, neither the state nor the municipalities here in our area had any type of eviction moratorium for commercial leases. They had it for residential, but nothing for commercial. It doesn't help because at the time, all the courts were closed. So, that's just, you have to be careful about that. Really, even if it says it in the lease, it really shouldn't, it's not allowed. And tenants not paying the rent doesn't mean that the landlord can block the tenant's access to the property. Okay, so it's just talking about landlords illegally resorting to self-help evictions by changing the locks, entering the leased premises, taking over the space, throwing stuff out onto the front yard, so to speak, by the sidewalks. Once these things happen and it does go to court, the courts, I think, would generally really frown upon that from happening because they look at the circumstances and they look at what you were able to do as a landlord or even a tenant if you left the place a mess and you didn't clean up. They will look at those facts and circumstances and not really be so happy to see that this has happened by the landlord. So I would just suggest that you really kind of take a look at the facts of your situation and also the contract language and where you're at, again, in the lease. So, and doesn't mean that just because COVID, that our stay-at-home orders are over with, doesn't mean that we might not have another stay-at-home order in the future. So just be aware of that. This might be kind of a rocky road where in a couple of months, you might have to have another one, and then another one and another one. So, being aware of what you have right now in your contract or in your lease is really important. So the other thing I would suggest is, as a takeaway, don't assume anything, okay? Don't assume that you're not going to be evicted. Don't assume that you can get away scot-free, that you're going to be all right. You want to go ahead and just because you think, oh yeah, we signed the lease, we signed the contract, we didn't think COVID was going to happen, I don't have to do anything, I don't have to pay. Well, not necessarily. The courts in general look at these clauses very narrowly. They look at the acts of God, the force majeure clauses, they take it very, very narrowly. A lot of times they might look at the actual language that's in there. And so a clause might list events to excuse fulfilling the contract. And it might not mention viruses, pandemics, quarantines, labor disruption, government orders, all right? If they don't mention it and there's nothing of that kind or similarly, then that might not be, you still might be enforced. And so you still have to kind of, take your lumps and maybe pay those damages. Also be aware of catch-all phrases that might be in there. It's kind of, I call them the kitchen sink type phrases in a contract that, maybe will only be enforced if virus or pandemic is like the other examples. So as again, if you have a virus, a plague, a pandemic, a quarantine, a government action, that maybe prohibits you from having to do this, that might give you an out, give you a kind of get out of jail free card. And then these clauses only apply to events that neither party could reasonably or kind of expected. And, if you signed a contract 2 weeks ago or a month ago, and you knew that COVID was there in that the stay-at-home order was happening, then that would probably not give you anything because you would have had knowledge. And the courts would probably be very unsympathetic to this. Now, let's say you signed the contract 2 years ago and you're kind of having to perform maybe now, or maybe it's a series of things, then that might excuse either the whole contract if it's just one thing, and or it might be that series that you might be excused. It all depends again on the timing of the contract and when it was signed. So 2 years earlier, you might not have any idea that this would have happened. And if both parties had that intent, then you might be really, really helpful in this. Again, it depends on all the facts, the language of the contract, and the timing of where you're at in performing the contract. And, if I had to give you advice, have an attorney look at the contract, kind of take a look at it and see what he or she can do for you. All right. So that's all I have at this point. But Tasha, we have some questions. If you have questions, I can't give necessarily legal advice, but I can kind of give you a generalization. So if you have questions, please put in the chat what you might be, that I can try and answer for you. But in general, I manage the Microenterprise Program that's part of community economic development. And we offer free legal assistance for businesses, small businesses and nonprofits, existing businesses, new businesses, not-for-profits. We help them in those ways. We help with one-on-one legal help if it's not myself or staff attorney Marlene Elliott to take the case. We have over 330 volunteer attorneys who would be willing to help you. We try and do whatever we can. We try not to go to court because we want to help build a business. We're not into business divorces or bankruptcies. We will help because of the COVID crisis. We will help if you've had a contract or a lease affected by COVID. We would be able to help you in those circumstances as much as possible to try and negotiate some sort of a settlement or a resolution to try and avoid court. And we also do business legal workshops, and we do counseling through legal clinics. We have a shout out tomorrow, legal clinic at Grace Hill, a virtual clinic where we have attorneys from Cape Sokol who are there with also our staff attorney, Marlene Elliott. And so if there are other things, if you're eligible for us, if you're interested in becoming a client, you can contact us at ced@lscm.org. That's our email address to get a hold of our program, or to call the 314-256-8752 and go ahead and get a hold of us. We have normally, if you have been affected by COVID in any way, let us know when you're contacting us. Generally, if you are a for-profit business, clients can't make more than, and then we're looking at household income, clients can't make more than 300% above the federal poverty level for that family size, and no more than $7,500 in savings. And that's really, again, fact specific. And our paralegal, Richard, would be willing to help you kind of look at that. And for nonprofits, we accept clients who serve underserved individuals in Eastern Missouri and show that the nonprofit cannot afford to pay for legal help. That's kind of in general. And if you're not affected by COVID, your business is not affected by COVID, we normally require a business plan. You can submit one of your own. And we also have some on our website, www.lscm.org. And you go to Microenterprise Program, and we have a for-profit and a nonprofit worksheet for you to fill out. And then you can email that or mail it to us, something like that. And we would go ahead and take your information and intake. So that's what I have right now, if there are any questions. Tasha?
Thank you, Ms. James. We'll now take some questions from our viewers. One viewer asks, how common is it to have virus or pandemics mentioned in contracts specifically?
I don't think it's that often. It all depends on the intent of the contracting parties. I think, sometimes you can have contracts that are really, really, really long, and you could try and put everything you can think of in the acts of God part under for force majeure clauses, and they might have it in there. But if there's something like quarantine, pandemic, virus, plague. That some of the older contracts might have that language in there, especially from the 19th and 20th, earliest 20th centuries, might have that in there. But it's not that common. And that's why you have to look at those things. And then sometimes if you have things that are similar to it, courts can kind of interpret that. So it just depends.
Thank you for that answer. Another viewer states, I signed a lease and it doesn't mention anything about any of the clauses you mentioned. However, what is a gap filler? I saw that on one of your slides. What exactly does that mean?
A gap filler means something that Missouri law, typically whatever the state is, but we're here in Missouri. So Missouri law has created, usually through past cases that have maybe similar factual situations that can interpret how the court decided in that particular case can apply in your particular case. And so like a frustration of purpose, impossibility, impracticability, those are gap fillers. Sometimes you might not even have an act of God clause in your contract or your lease, but that also might mean that it can apply. It just depends on, I'm looking at the whole of the contract and seeing what else is in there and also what kind of notice provisions you have.
Okay, great. Thank you, Ms. James. We have another question or another situation for your consideration. This viewer states, I run a business, but it is not an essential business, and I had to stay closed during the lockdown. I have a written contract, but it doesn't mention when I have to pay, and I think I owe my vendor $5,000 for goods I received. I haven't been able to sell the goods because I was forced to close. Do I have to pay that amount now, or can I wait?
Well, the best thing you should probably do is contact the other party and let them know that obviously you've been closed and you can't sell these things. And so it's been, I guess, impossibility you could possibly use. But I mean, you still have to pay at some point, but do you have to pay now? You might also look at the custom or the what's kind of normal for these types of situations in your industry. If it's something upon notice, is it upon receipt of the goods? Is it 30 days? Is it until your business reopens? You just kind of look at that custom. And then also, have you been dealing with this particular party for a long period of time, or is this a new relationship? And you don't necessarily know how they are going to answer. So, I mean, the best thing to do is be prepared to pay. You probably won't be excused from paying, but you might ask for a delay and try and mitigate those losses, or maybe see if you can do some sort of workout, a settlement in some way.
Thank you. Another viewer states, what if the force majeure clause is weighted in favor of the lessor and not the lessee? Can that be altered due to the current situation?
So rewriting the contract, I guess, is the answer, is the question. That if the force majeure clause in the contract is weighted towards the lessor, so in the lease, it's for the person who's getting this. So yeah, I mean, it depends on the situation. I think if those facts in the clause and how it's written can kind of benefit the other party, it's possible, but it really does take kind of an eye for an attorney to take a look at and see if it applies in your situation. Would be my best bet.
And that same viewer asked, what kind of attorney should I seek for what kind of attorney should I seek for this assessment of my lease?
Well, there are many different types of attorneys because there's many different types of law. For instance, a patent attorney might not be the best bet for you. Someone who deals with business, if it's a contract, someone who deals with business, legal business issues, we call them transactional attorneys. They might or might not be trial attorneys. You have some that kind of can represent a lot of different things. It can be a criminal lawyer, it can be a family lawyer. You want someone who's really good about looking at contracts at these things, and they look at it very often. If not, if it's a lease, then you want someone specifically, an attorney who deals with real estate. You might have those that have a couple of those things in there, but it would be better than maybe a family law attorney or a criminal attorney. Not to besmirch them, but they have probably more subject matter knowledge than others.
Excellent. Thank you, Ms. James. I don't see that we have any additional comments or questions for you at this time.
Thank you very much for having me tonight. I really appreciate it. And I hope that you've been able to benefit from this at all possible. And I haven't created more questions for you, but we're glad that you're here and that you're interacting with Legal Services of Eastern Missouri. So we do have something next week, I believe, after Memorial Day. And I will be doing this as well. It's going to be a Facebook Live event, kind of like this. And it's about information for legal information for small businesses and nonprofits as they reopen. It's not only making sure that your space where you're at, if you have space, but if you're able to reopen, and if you have staff, or even if you have clients that come in, to go ahead and see how they can help. You can make it ready for them to transact business with you. The other is to deal with your employees, or maybe independent contractors that you have staff, and how to make sure that you are not going to be subject to any type of claims of discrimination, especially if they might be very hesitant about returning to the workplace in person. So we're going to talk about that next Wednesday, May 27th, on Facebook Live, and look forward to having you come back.
Excellent. Thank you, Ms. James, and thank you to our viewers for joining us for another Money Monday. Today's session and recordings from our prior events are saved on our Facebook page. Slides from this presentation and other information about COVID-19 updates can be found at our website at lsem.org/COVID-19-updates. As Ms. James mentioned, we have upcoming Facebook events, one particularly for small businesses and nonprofits next week. So join her next Wednesday at 2 o'clock. We also have several Facebook events coming up this week, one tomorrow at 3 o'clock on special education, and another on Thursday on Medicaid rights. For additional information, please like and follow our Facebook page so you can stay on top of all the updates. Thank you again for joining us, and good night.
Good night. Thank you all.